The Supreme Court decision in the case of ROSELYN AGACID versus People of the Philippines and Maria Alexandria Becerra. In denying the petition, this court squarely ruled that Republic Act 9262 applies to lesbian relationships. Contrary to petitioner's submission that the foregoing disquisition in the case of Garcia versus Dryland was a mere obiter dictum. The court notes that one of the issues raised in Garcia is the supposed discriminatory and unjust provisions of Republic Act 9262, which are likewise violative of the Equal Protection Clause. The foregoing discussion of the court as to the applicability of the law to lesbian relationships is clearly a resolution of the particular issue raised in Garcia and not a mere obiter dictum or an opinion of the court. The statement of the court that there is likewise no merit to the contention that Republic Act 9262 singles out the husband or father as the culprit further amplifies that the issue of whether Republic Act 9262 only applies to male perpetrators was indeed raised in the said case. Thus, when Jacinto said that the law likewise applies to lesbian relationships, this was in response to the petition in Garcia, as it shows that the law is indeed not discriminatory. Republic Act 9262 seeks to protect women from the various forms of violence they endure in their private relationships. The nature of this social legislation is to empower women who find themselves in situations where they are left vulnerable to their abusers who are their intimate partners. The dynamics within the intimate relationship of two people, with all its intricacies, difficulties, and power play, is the context within which the law places the violence it penalizes. Aside from being a gender-based issue, violence against women is necessarily a power issue. To quote the Regional Trial Court's order, the purpose of Republic Act 9262 is to protect and rescue women and their children from distinct and unique forms of violence known as violence against women and their children. It is the distinctiveness and uniqueness of violence against women and their children that sets it apart from other crimes. Violence against women and their children owes its distinctiveness to the domestic, private, hidden, and invisible relationships from which these forms of violence emanate and gain significant uniqueness. A lesbian who maltreats her female partner physically, psychologically, economically cannot be any different from a male perpetrator of violence against women and their children, or a mother-in-law who conspires with her daughter-in-law's partner to commit violence against women and their children against her. The same object of Republic Act 9262's protective mandate is given succor, the woman. The violence is as distinctive and unique as those that make violence against women and their children committed by men deserving of this special attention. Indeed, to exclude lesbians from the protective mantle of Republic Act 9262 would create an artificially and arbitrarily privileged section or domestic violence that is exempt from scrutiny when other facets of domestic violence somehow similarly situated would otherwise be ordinarily prosecuted as such. To be sure, while intersectionality would better inform the distinctiveness and uniqueness of lesbian relationships, the same impunity, invisibility, and imbalanced power relationships that characterize violence against women and their children committed by men, and what Republic Act 9262 aims to eradicate also infect and afflict lesbian relationships. As experts have put it, abusive tactics can be used in any relationship, regardless of gender.